I'm Devin Stone. I am a practicing lawyer, and I'm also the creator behind the YouTube channel LegalEagle. When I'm not in court, I am creating YouTube videos just like many of you are. I also run a website called copyrightcourse.com. As you can imagine, since I have the largest law-related YouTube channel in the world, I talk to a lot of creators. Creators have a lot of copyright-related issues, and everyone likes free legal advice. Unfortunately, creators have a lot of misconceptions about the law when it comes to online creation and copyright law, and there are a lot of myths out there about copyright law. Luckily, I have extensive experience with copyright. I have represented movie stars, Fortune 500 companies, artists, you name it. And so I want to take some time today and talk about some of the 10 biggest myths in copyright law that people tend to misunderstand when it comes to online creation. So let's start with copyright myth number 1. Copyright can protect my ideas. The thing about copyright law is that it does not protect ideas. It really only protects expression, and that expression has to be in what we call a tangible medium. It has to be written down, it has to be recorded. Just because you have an idea, that doesn't mean that you can get copyright protection for it. Copyright doesn't apply to ideas, especially intangible ideas. Sometimes you can get protection for things like inventions or specifically useful ideas, but that's what patent law is for. And there are some very specific requirements to get a patent. So if you wanted to protect an idea, copyright is not the way to go. So for example, you could create a movie about a British spy. That's just an idea. But you can't create a movie about a British spy named James Bond who drinks martinis shaken, not stirred. That would be copyright infringement because there is tangible expression about this thing in the form of the 30 or so James Bond movies that are out there. So copyright does not protect ideas. Copyright myth number 2. Copyright only applies to fine art. The copyright laws are written such that almost anything is considered art within the definitions of copyright law. Under the Copyright Act, which you can find at 17 USC 100 and all of the subsequent statutes, under the Copyright Act, almost anything that is the work of original authorship plus a small amount of creativity qualifies as art. I won't go into all of the requirements for creativity, but in order to receive copyright protection, you have to have some creativity that goes into it. We don't want people to just make absolute copies and call that art. But the bottom line is that copyright isn't just about fancy paintings in a museum, but it can be almost anything. In fact, you are probably making art right now. The cat videos that are on YouTube are considered art. Selfies are considered art. It's all art, and almost all of that can receive copyright protection. So just because it's not a work of fine art doesn't mean that copyright protection can't protect that thing. Copyright myth number 3. You have to register your work with the government to receive a copyright. In fact, that is not true at all. Copyright applies immediately when you add your expression to a tangible idea. In other words, if you start writing a book and you type it into a computer, copyright applies. If you write something down, copyright applies to that. If you take a picture and it goes into the memory card of the camera, the copyright applies. So long as your art, and remember, almost anything qualifies as art, meets the requirements for copyright, the second you add it to a semi-permanent or tangible medium, you get a copyright in it. You can protect your work against others. You don't need the government's permission. Now, of course, there are reasons why you might want to register your artwork with the Copyright Office, but it's not necessary to get copyright protection in the first instance. There are just certain benefits, but in terms of getting a copyright and having a property interest in the art that you create, that happens immediately, and you don't need a government to give that to you, which is different from things like trademark and patent, which often do require government permission before you get those types of IP. Copyright myth number 4. If it's on the internet, it's in the public domain. I hear this one a lot, that people confuse the idea of something that is public with things that are in the public domain. Being public and being in the public domain are two very different things. A work will fall into the public domain once copyright expires. This will typically be many years after the author's death. It could be as many as 120 years after the author has passed away. And while a work published on the internet may be publicly accessible, it's certainly not in the public domain. Think about it. All of your favorite things are public or are on the internet, but they're still copyrighted. Just because someone publishes a video online doesn't mean that anyone can use that for any purpose. And the only way to be absolutely sure that a work is outside of copyright is if it was released before 1924. At that point, everything that was created before 1924 has passed into the public domain. Everything else after 1924, 1923, it gets complicated. But the bottom line is, most of the stuff that you probably want to use is copyrighted. Copyright myth number 5. If there's no copyright notice, it can be used. This is something that dovetails with the prior copyright myth. It used to be the case that you had to put one of those C with the circles around it, the copyright notice, on a given piece of artwork in order to receive copyright protection. In fact, for a work before 1978, you had to use that notice to provide notice to people that, in fact, this artwork was copyrighted and they couldn't go around using it for their own purposes. Now, however, copyright will apply whether there is a copyright notice on it or not. In fact, most of the stuff that you see on the internet, whether it's YouTube or Instagram or what have you, probably doesn't have a copyright notice on it, but it still falls under someone's copyright. So just because it doesn't have a copyright notice doesn't mean it's fair game to do whatever you want with it. Copyright myth number 6. If I alter or transform the underlying work, it's not copyright infringement. AKA, if I change someone else's work, I can claim it as my own. Copyright obviously prevents people from copying your work, but it also prevents people from making another copyrighted work based on that particular work. And this myth is a little bit tricky because a lot of people confuse the requirements for fair use. But think about this. Think about Jurassic Park. Before it was a movie, it was a very famous book by Michael Crichton. Steven Spielberg wanted to make a movie out of Jurassic Park, so he had to get permission from Michael Crichton to first turn the book into a screenplay and then turn the screenplay into a movie. But at each one of those steps, there was a copyrighted work. You had the novel, and then you converted the novel into a screenplay, and then you converted the screenplay into a movie. Those are what are called derivative works. It's altered and transformed, but it's still copyrighted. And when you make an original piece of art, you get to control who gets to alter and transform that work. So Michael Crichton, the author of the novel, was able to control who made a screenplay and eventually a movie out of that work. I'm sure he licensed the right to make the screenplay and movie to the writer of the movie and eventually Steven Spielberg, who made the movie. The bottom line is that the act of copying or adapting someone else's work is a restricted act that only the copyright owner is allowed to license. Any adaptation will be legally regarded as a derivative work. So if you simply adapt the work of others and transform it, it'll still be their work, and they have every right to object if you publish that work without their permission. And they're also entitled to reclaim any money that you make from selling a work that is based on their own. The only safe option is to create something that is not copied and not adapted from the work of others. To seek permission from the rights owner, you should expect to pay a fee or other royalties to do this, or to make work under the fair use exception. Copyright myth number 7. If I recreate a work from scratch or I play all the notes myself, it's not copyright infringement. Believe it or not, if you recreate someone's work from scratch, say you trace someone's photo or you play a cover of a song of someone else, that's considered a derivative work. All you've done is really transformed or adapted the original work on which it was based. So for the same reason that Michael Crichton could control who could make a movie based on his book Jurassic Park, anyone that creates an original piece of art is allowed to control people from say, recreating that thing from scratch. People get into a lot of trouble with this in terms of fan art, in terms of cover songs, because just because you have played every note on the instrument yourself and you sang a song yourself, it's still based on that original work, and it's still considered a derivative work. So just because you play it yourself doesn't mean that it's not a derivative work, and the rights inure to the original artist. And on top of that, if you went to a museum and you saw a famous painting and you painted almost an exact copy, or even a version of that painting that is different from the original, that's still considered derivative work, and it would be copyright infringement if the original work is still under copyright. If you go into a museum and you start painting a version of a Monet painting, then that's not copyright infringement, but only because that painting is out of copyright. Copyright myth number 8. It's okay as long as you use less than 5 seconds. It's okay if you use less than 200 words, or it's okay if you use less than 10%. Unfortunately, there is no such thing as the 5-second rule, or the 6-second rule, or the 30-second rule, or the 10% rule. There are no bright line rules in terms of just using a very small amount of a copyrighted work. It's just simply not the case that you will ever find a rule that says, as long as you use less than this amount, it's okay. Unless it is explicitly allowed under fair use, which we'll talk about in a second, or fair dealing if you're in the UK, any unauthorized use of a copyrighted work could potentially lead to legal action, even if you use a single frame out of a video or 1 second of a song. When you're using quotes or extracts, there's no magic formula or percentage that can be applied, and each case has to be viewed on its own merit. The bottom line is that small use does not equal fair use. Even the smallest of uses can qualify as copyright infringement. Fair use is a very complicated formula that relies on the analysis of 4 factors that you have to go into every time you are going to use someone else's copyrighted work. So it's always important to make sure that you know the law in this particular area before you use someone else's work, because just because it's small, just because it's a tiny fraction of the underlying work, it doesn't mean it's okay. And I've seen a lot of creators get into a huge amount of trouble because they thought it was fair use when it wasn't. Copyright myth number 9. It's okay to use, copy, or publish other people's work if you don't make any money from it. This is a common misconception and is very, very wrong. Whether you're making money from your own artwork is something that is taken into consideration, but it's also not dispositive. And just because you're not making money from it doesn't mean you're allowed to use other people's art. Except in specific circumstances that are permitted under the fair use rules, any copying or publication without the consent of the copyright owner is infringement, whether you're making money or not, or whether you're receiving AdSense, or whether you're a business or not. You could face legal action regardless of the fact that you actually made money from the thing that you're putting out there. Copyright myth number 10. Fair use doesn't apply if you're a business or are making money. I was talking to a creator the other day who runs an extremely popular multi-million subscriber YouTube channel who decided not to do something that was clearly fair use because he thought he was excluded from doing so because he was a business and was making money from it. That's a factor that goes into the fair use analysis, but that is not the case that it will exclude you from using fair use. I rely on the fair use exception a lot on my channel, where I talk about famous movies and TV shows, and I make AdSense from it. I run a business. YouTube in particular relies on people making use of the fair use exception to be able to use copyrighted works in creating new YouTube videos. And whether you're making money from it, most of the YouTube creators that are out there are making money, whether it's through sponsorships or through AdSense. But just because you're making money from it doesn't mean that you can't use something in a fair use way. It's a factor. It weighs against a finding of fair use. But for the most part, it's not dispositive. And I see a lot of people who are making a lot of money using underlying work under a rubric of fair use. And you know, if even some of the biggest brands in the world, like Nike or Coca-Cola, could use someone's copyrighted work in a fair use way, and the fact that they were making money from it is not going to remove the fair use protection in most circumstances. So let's throw in one more bonus copyright myth. Copyright myth number 11, fair use requires permission from the rights holder. We've been talking about fair use, some of the pros and cons, but one of the biggest pros of fair use is that if your use falls under fair use, you don't need permission from the original artist. You don't need permission from the rights holder. Fair use is a right. You can find it in 17 U.S.C. 107. It doesn't apply to everything, but if it does apply, then you don't need permission from the rights holder. If fair use does apply, you can make money off of using other people's work in a fair use way. You don't need their permission. You can do it in a commercial way. As long as it applies, then it's fair game. Fair use is a right. It is not an exception to the copyright law. It is written in there that every creator has a God-given right to make whatever fair use art they want to. And frankly, I think more people should. As a lawyer with extensive copyright experience, I feel comfortable dealing with these issues, but I also recognize that creators out there might not. I don't think that that's particularly fair. That's why I created copyrightcourse.com, to give creators the tools that they need to deal with copyright issues. Whether you want to learn how to use fair use to your advantage or how to fight off all of the copyright trolls out there, it teaches people how to use copyright for good. The thing is, what you don't know can hurt you. The giant music labels and movie studios know what they're doing. They have teams of lawyers who do nothing but scour the internet all day looking for videos to monetize. I know because I have received lots of content ID claims from movie studios, and I have beaten every single one. I have beaten dozens and dozens of claims. You'd think that they wouldn't file a claim against a practicing lawyer, but here I am. But for other creators, I recognize it's sort of David versus Goliath out there. And on top of that, I know from personally talking to creators that tons of people hold back from creating art out of fear. Sometimes that fear is justified, but sometimes it's completely unfounded. I don't want creators to hold back because they're worried about copyright. I want creators to make as much art as possible. I'm only one man. I can't meet one-on-one with the thousands of creators who are out there and have issues with copyright. But what I've done is I've taken all of the questions that I've received over the years from creators, and I've answered all of them. All of them. And I've addressed the questions that creators don't think to ask, but really should. I took all of that and I turned it into a system that anyone can follow and use. I break it down, but I also point you to the actual law so you can dig in further as is necessary. And on top of that, I even give you the actual scripts that I use as a lawyer to fight content ID claims, appeals, and DMCA takedowns. In fact, I turned them into easy to understand templates so that anyone can turn them into custom defenses for their particular channel. All you have to do is plug in the name of your channel, the facts that apply to you, and you can copy and paste that into the YouTube Content ID system. And this is the same template that I have used to beat every single Content ID claim that I have gotten on my channel. And I'm super excited to announce that we've worked out a deal just for the followers of this channel, that there should be a link below this video. If you click on that link, it'll take you to a page that will give you a special discount, a huge discount on copyrightcourse.com, either the regular version or the premium version, that is just for the followers of this channel, just for being you. So click on that link for a huge special discount. Also, if you want more information about the course or about copyright law in general, or you can find my contact information at copyrightcourse.com. Again, that's copyrightcourse, all one word, .com. But either way, just get out there and make more art.